Memorandum of Association Section 256. The Memorandum of Association is a legal document that sets out the constitution and fundamental principles upon which a company operates. It defines the company's objectives, powers, and scope of operations, outlining the framework within which the company can conduct its business activities. Key components of Memorandum of Association. 1. Name clause. Specifies the name of the company, which should be unique and not identical to any existing company name. The name clause defines the corporate identity and branding of the company. 2. Registered office clause. States the official address of the company's registered office. This clause identifies the jurisdiction within which the company is registered and where legal notices and communications can be served. 3. Object clause. Defines the main objectives and purposes for which the company is established. The object clause outlines the specific business activities that the company is authorized to undertake. The Companies Act, 2013, allows companies to include multiple objects to provide flexibility in business operations, subject to compliance with legal and regulatory requirements. 4. Liability clause. Specifies the extent of liability of the company's members, shareholders. Companies may be limited by shares, guarantee, or both, depending on the liability structure outlined in the MOA. The liability clause defines the financial obligations of members in case of company debts or liquidation proceedings. 5. Capital clause. States the authorized share capital of the company, which represents the maximum amount of share capital that the company can issue to its shareholders. Companies can alter their authorized share capital through special resolutions passed by shareholders in general meetings, as per the provisions of the Companies Act. Legal framework and amendment. 1. Companies Act, 2013. The Act mandates the contents, format, and legal validity of the Memorandum of Association, ensuring compliance with statutory requirements and corporate governance norms. Amendments to the MOA require approval by shareholders through special resolutions and submission of requisite forms to the Registrar of Companies, ROC, for registration and legal effect. 2. Scope and limitations. The MOA defines the company's scope of activities and limits the powers of the company to those expressly stated within its clauses. Any acts or activities outside the scope of the MOA may require amendments to the MOA, ensuring alignment with the company's evolving business needs and strategic objectives.